Okay, I think that's everyone in from the waiting room now. So welcome everyone. Welcome. Thank you for joining us on the morning after the football before. We're very grateful for you for you being here and to give you this sanctuary, if you like, to nurse your sore head before having to go out and see the boss or the team, however it may be. Thank you very much for joining us. My name's Gary Smith. I'm one of the partners here at Knockholds in the employment team. I'm joined today by my colleague Joanna Sutton, one of our employment lawyers, and we're going to be speaking about how to avoid employment tribunal claims and how to look to protect your business more generally. We are joined today by our colleague Katrina, who's kindly hosting the session today, and we'll deal with any technical issues we may have. If you do experience any technical issues, pop something in the chat box, and Katrina will hopefully be able to help you with that. So Joe and I are going to be speaking for about just shy of an hour and a half today. As is typical with these Zoom meetings now, we will try and leave everyone on mute if we can, please. But if you've got any questions, anything crops up in the meantime, please do pop it in the chat box, and we will look to pick those up for you at the end. If there are any particular questions that are particularly sensitive or confidential, Joe and I will be about for the rest of the day. If you prefer for us to answer those questions or chat with us offline, we are happy to do that. So what are we going to cover today? Well, firstly, why does this matter to you? Why should you care about trying to avoid tribunal claims? What could it cost you? I'll then pass you over to Joe, having set the scene, who will look at how to avoid a claim. And then I'll just spend a few minutes right at the end just looking at the other protections you can look to consider, because it is all well and good avoiding tribunal claims, and you should certainly seek to avoid them if you can, but that's not much comfort to you if your employee, having been made redundant or dismissed for misconduct, whatever it may be, then takes your client database, your customers, and takes them off to a competitor and destroys your business that way. So we'll look at that as well. So why then does this matter? Well, we'll all be familiar with the effect of COVID. We've all seen the huge number of people who are losing their jobs currently. We're looking at an additional about 1.2 million people currently seeking job seekers allowance, and they are only the people who are seeking job seekers allowance. There are a lot more people who have been made redundant or gone out of the workplace who are not seeking that. There are currently around 4 million people still on furlough, and of course from tomorrow the furlough scheme becomes less and less attractive to employers to use, and so and that will then come to an end on the 30th of September, and there's no sign at all of the government looking to extend the furlough scheme beyond then. Now, although some of those 4.2 million will be employed in businesses that will rebound, maybe they're shut like nightclubs. Its best guesses at the moment, there's going to be another 1.5 million people losing their jobs over the next sort of 3 to 6 months. And that's going to have a massive impact on employers across the country. You may have some of your own staff, you're unsure, they're on furlough. Do you have them back? Do you not? You're unsure. Now, one of the biggest impacts that that amount of job losses has had is that the employment tribunal system has come, frankly, close to collapse. Claims are up by, single claims are up by 25%, multiple claims are up by 82%. And where employment tribunals normally aim to deal with cases within 30 weeks, so that's from the day the claim is issued to the day judgment is handed down, they're now currently running at 46 weeks. But that's only on the ones where the judgment has been handed down. So that period is going to extend. It's going to go well beyond a year. And we're already looking at hearings of more than 1 day being listed for late 22, and more than 4 days are now into 2023, which is simply too long, to be honest, for justice to be done. Now, what is our experience of all of this? Well, you'll be familiar with the fact that the limitation period in any tribunal claim is normally 3 months then to trigger the ACAS early conciliation period. And then depending on various complicated rules, you get an extra 10 more weeks to submit the claim. The tribunals then state that they aim to get those claims out within 5 working days. They are not even close to getting those out within 5 working days. We had an instance just a couple of weeks ago where the claim was issued on the 28th of February and it wasn't sent to the employer until the 10th of June. So employers are sat there thinking, okay, great, I've done my process, I've done this right. How long do I have to wait? Well, we can't tell you at the moment because the system is just taking so long to get things processed. We had another case where a claimant, a former employee, failed to comply with the tribunal orders, failed to get us documents, failed to deal with statements. We wrote to the tribunal looking to get the case struck out. 13 weeks later, we heard from the tribunal. And of course, by then they'd got themselves sorted, they'd caught up, but the whole case was just pushed right back and made much more complicated. The London Central Tribunal, so that's where most of the London tribunal claims are heard. Well, they've just simply closed their telephone line. You can't get through to them. You simply can't chase up that application or that letter. You can only email. And that's despite the fact that most hearings are taking place by video. Now, why does this matter to you? Well, on the one hand, the fact there's delays means you unfairly dismiss someone, you've got the money in your bank account for a lot longer. But these things drag on, they impact your ability to run your business, they just grind you down. You also run the risk that your staff who are involved in the processes leave, go and get other jobs. If you've got a 2-year period, you could well have some senior managers perhaps leave who are running the redundancy. If that happens, who are you going to call as a witness? How are you going to defend your case? So these are material challenges, and it makes it all the more important that we get things right, and not only get them right, but that they are seen to be right, so that claims are not brought against you in the first instance. Before I hand you over to Joe, then it's always worth just reminding ourselves, well, what could an employment tribunal claim cost you? Now, at the risk of starting this webinar off with too many statistics, we've got the potential awards there. This is for the 1920 year, so before we got into this, to the current lockdowns. Average awards you can see there, quite considerable when you start getting into sex discrimination, disability discrimination, age discrimination. And remember that a big part of those awards is what's known as the compensatory award. So that is their financial losses flowing from their dismissal or the discrimination. Now, if they get another job after 3 months on the same wages, the most they can recover is 3 months' pay. If they get another job after 6 months on the same wages, the most they can generally recover is 6 months' pay, etc. But if you've now got a situation where there are so many people being made unemployed that the jobs market, which to be fair has held up pretty well, but cannot get people into work quick enough, you lose your tribunal case. You will pay more compensation now than you would have done 2 years ago, simply because the employees cannot find another job. So that's a material issue. The other costs involved in fighting tribunal claims, well, firstly, you've got your legal costs. Now, legal costs are not normally recoverable in the employment tribunal, even if you win. For that reason, lots of our clients take out employment tribunal claims insurance to try and protect from that. You also have The issue of management time, say 3 days at a tribunal, preparing the documents, witness statements, liaising with the staff. You've got all the emotional drain, the stress, the sleepless nights. There is a significant number of employers or respondents in the tribunal will wait until about 6 months in and they go, oh, look, let's make this go away, settle it. I've got to get on with my business, which of course just adds to the cost. And then finally, you've got the reputation damage. Now, all employment tribunal judgments are now published online. Now, how many people tend to go and look at them is another point. But prospective employees are now starting to look at this and what damage could that do? You don't even know. They've not even applied to you yet, but they're put off from applying for you by a judgment, adverse judgment. So there's a huge number of reasons why you really do want to try and keep out of the tribunal now more than ever. And I'll pass you over now, having set that happy scene for you. I'll pass you over to Joe to look at how to avoid a claim.
Good morning, everyone. I'm looking forward to the day when we don't have to do this on Zoom anymore and we can see all of you guys in real life. But for now, hopefully this will be of interest to all of you. So I'm going to talk a bit about the basics, and it's stuff that a lot of you will be familiar with anyway, but it's worth remembering and going through these basics just so that you're absolutely getting the groundwork right, because so often it's where we see these things not quite right and it causes problems when if you do unfortunately end up in the employment tribunal. So the very first thing that I will start with is to stress the importance of an employment contract. Now, most of you will know this already, but the rules changed in April last year, whereas before you had to give an employee or a worker a contract within 8 weeks of them starting work. In April, so when we were in the throes of COVID just kicking off last year, the rules changed and now it's a day one requirement. So you need to give an employment contract to an employee or a worker from the very first day that they start with you. And that's really important because there's also new information that you need to include within the contract. So as well as all of the things that you used to have to include within the contract, you've now got to include other details. So things like what training is available to that member of staff, who's going to pay for it, full details of all their right to time off. So things like maternity or paternity leave, for example, but also other things that you might offer, like a sabbatical or study leave. You need to include all of those details within the contract as well. And you also need to give full details of benefits. So I think traditionally we would often include pension or life assurance or private medical, things like that within a contract, but you need to include details of all the benefits that are available to the employee. So stuff like gym membership, for example. So if you haven't already, now is a really good time to be looking at your employment contracts and just making sure that all of that stuff is in there, and also adjusting your processes so that the contracts are being given to the employee from the first day of their employment. So it might be that you send out the contract with the offer letter, for example, rather than waiting for them to start work when things could quite easily be missed on that first day, or you make sure you incorporate it as part of your induction to make sure that from the very first day they're with you, that they get that employment contract. And that's really important for two reasons. The first is that an employment tribunal can award compensation if you don't give an employee a contract. So it's a claim in itself. It's only worth a couple of £100 for an employee. So it's not something that you normally see as a sort of a claim on its own. But if someone's going to put a claim in for unfair dismissal or discrimination or something like that, they're going to stick that in as an additional claim. So it's a nuisance for you. It's another couple of £100 that you may have to pay to the employee. But also the main issue is that if you haven't got a contract, you don't know what the terms of the employment are. So it comes down to what's been happening on the ground. You get effectively an unwritten contract of all of the things that have been happening on a day-to-day basis, which is fine when you're merrily going along and getting on with that employee. But once they leave and they've taken an issue with you, they're going to say that they were doing something totally different potentially from what you remember them doing, and so you're going to be at odds with each other. So you really need to make sure that there's a written contract, just so that everything's written down and you can refer to things when they go wrong. And that's really helpful, just to be able to say, no, clause 10 of the contract says X, Y, and Z, and it's clear as day. There's going to be no room for disputes there. So pretty basic starting point, but cannot be underestimated how important the employment contract is. You know, you'd be surprised. We very often do see people who haven't been issued with an employment contract, and it just makes things all the more difficult if things do go wrong. Privacy notice is the next thing that you need to make sure you're giving to employees. I know many of you I've spoken to as Knockhold's GDPR expert about the importance of data protection, and this is basically a document that you need to give to all your staff to let them know what information it is that you're collecting about them, what you do with it, how long you're going to keep it for, who it might be shared with. And again, you need to do that from the very start of their employment. Technically, you should also be doing it for job applicants, because you're still collecting personal information from them. So there should be a separate privacy notice that you're giving to them. And again, I see this go wrong all the time when an employee has fallen out with you, because not only are they going to potentially try and take you to the employment tribunal, they also then might try and bring a claim about the way that you've looked after their personal information and make a complaint to the Information Commissioner's Office, who are the data protection regulator. So again, this is just something that is a really quick win to make sure that you've got in place just to head off any of those kind of issues, so that the employee can't then, you know, try and make a complaint that you haven't told them what you're doing with their personal data. Next thing to think about is to obviously have good policies and procedures in place. That's not a legal requirement. The only policy necessarily or procedure you need to have in place by law is a disciplinary policy and a grievance policy. And again, it's just useful to, apart from having those ones that you're legally required to do, to have other policies in place that you can use to either guide you through a process or to point to when things go wrong. So someone's broken data protection, you know, policy, you can point to something in black and white that shows what it is that they've done wrong, and the employee can be under no illusion of the fact that they were required to comply with that. So having policies and procedures in place is really important, and it's also quite useful for certain things that are criminal offences that as employers you can be liable for. So on the slide there, I've got examples of bribery and corruption, and also tax evasion. These are criminal offences that you guys can be liable for if one of your employees commit one of these offences. But the good news is that it's a defence to have rules in place that you are making clear to the employee that you don't want them to be committing tax evasion on your behalf, or, you know, committing bribery, taking backhanders from public officials, or paying them. So if you've made it clear in black and white that they're not expected to do that and they're not allowed to do it, then it's much easier to establish a defence to those claims that you're not liable for the employee going rogue and breaching those policies and committing those offences. So those are a couple of areas that it's really important to have policies and procedures in place, particularly if you're in a high risk business where there might be a risk of bribery, or, you know, you are advising on tax or something like that. But there are other core policies that we would always recommend that you have in place, and they're on the slide there. So equal opportunities, that is the first thing that a tribunal will want to see if you are have a claim brought against you for discrimination. If you haven't got an equal opportunities policy saying that you expect your staff to, you know, behave in a certain way and not discriminate against others for, you know, age or disability and all those other protected characteristics that we're all familiar with, the employment tribunal are going to come down really hard on you. So equal opportunities policy is absolutely essential in our opinion to include within a staff handbook. Other things like whistleblowing, for the same reason that if an employee brings a claim against you for making a protected disclosure, say they've, you know, complained about a health and safety breach or fraud or something like that, and then they're saying that they've been treated badly because of it. Again, having a policy in place that sets out how you handle those kind of complaints is really important and can really help with the defence of a claim of that nature. Data protection, again, really important, just to make sure that you're setting out what the employees can and can't do with your clients' data, with information that they may be able to access, again, to show that the control that you've got in place. Social media, I think you've probably all seen the bonkers things that people put on social media, and somebody only has to have "I work at XYZ" on their profile and they start sharing, say crazy conspiracy theories. It could then potentially cause you reputational damage if somebody else sees that and thinks that that person is representing your business, even if it's on their private Facebook account or something like that. So having social media policies in place, setting out what they can do from a business perspective, and also potentially some of those restrictions on the information that they might share if they're linking their personal account to your business, is really important. And a really growing area that we're seeing at the moment is obviously hybrid working, with everyone kind of starting to hopefully adjust to the new normal and the lifting of restrictions and things like that. And for many businesses, you've probably not had home working, in place on a widespread basis, but it may be something that you're looking to do more of now that it's worked for the last year. Employees are keen to carry on working a mixture of home and office, and having some kind of policy in place that sets out what's required, the use of personal devices to be working, if they're working on a home computer, some kind of restrictions on the data that can be accessed, the fact that if they're working from home, they may be required to come into the office for meetings from time to time, all of those kind of things. Again, just setting the ground rules are really useful. And you can obviously have a policy about tons of other things. I mean, you can have policies about policies, and often a staff handbook can get quite sort of lengthy with putting all of these things in, and there may be other policies that you think are essential to your business, but certainly having these core ones in there are the ones that, as a minimum, we would always recommend if we're reviewing a staff handbook or your policies. And the other thing to bear in mind is obviously that these policies can become out of date, your contract can become out of date. So something that we spend quite a lot of time doing with our clients is every few years just reviewing it and updating it, because trends change. What's required to be put into an employment contract as of April last year has changed. So just having sort of a diarised date, every couple of years, to pull those documents out, because they are the most important things that govern your relationship with your employees. So make sure that you're keeping them under review. And with policies, we always recommend that those policies are non-contractual, so that they don't have to be followed to the letter. That's really important, because if you had a contractual policy, which then you're not following, so say a disciplinary policy, for example, which sets out the process that you need to follow. If you didn't follow that to the letter, potentially the employee could bring a claim against you for breach of contract. So having these policies in place is great. Ideally make them non-contractual, so that then you're not bound by them, absolutely, and that's important. We'll go on to sort of look at the process shortly, and it also means that you can change them more easily if you do need to update them in the future. So that's the importance of sort of policies and procedures. So once you've kind of got those documents in place, there's various things that you can use within them that will help avoid employment tribunal claims and protect your business. So the first one is a probationary period. So most of you will have a probation period normally in your employment contract. Now with the April 2020 changes, if you have one, you need to expressly state that in the contract, which normally most of them would do. But what we often find is that people don't really use those probation periods to their maximum effect. So, most employees know that during the probation period, they're being monitored, they're under a microscope, and you're looking at what they're doing, and you're making a decision about whether or not they're the right person for the business, if they can do the job properly. But what we often find is that time can quickly disappear, and when you work within the probation period, it's much easier to terminate an employee's employment if they're not working out, because they know that that they're under the microscope. So what we always recommend is to diarise that probation period. So generally it's sort of 3 or 6 months. If it's a longer probation period, you might want to perhaps put a sort of midpoint review in. And that's important because you might have somebody who at interview seemed like, you know, great, brilliant person for the job, and when they're actually working with you, they're just not quite right, or they're not quite hitting the mark. Whereas if you did a sort of mid probation review and just pull them up on a few things that you just need to get them to sort of step up a bit and achieve, that can be really useful, rather than you've gone through the recruitment process, you know, you've wasted all the agency fees and stuff like that. If you then turn around and get rid of them, it can just be an opportunity to really sort of get them to be the right person for the job. If they're not, then as I say, it's quite an easy way to terminate somebody's employment, and an employee is, you know, almost expecting that that's what may happen during that probation period. So normally you've got a shorter notice period, and it's pretty easy then to terminate them if they're not actually the person that they appeared to be at interview when you brought them in. So using a probation period effectively is really important, and making sure that you've got a note of when that comes to an end. And equally, appraisals. I think most people find that appraisals are a bit of a pain, but actually they're a really good opportunity for both employer and employee to look at what's actually happening on a day-to-day basis. So from the employee's perspective, you will be able to find out if there are any issues brewing, rather than just suddenly, you know, receiving a grievance from an employee, for example. If you're having that sort of opportunity to have an open dialogue with them about how things are going, then you're going to potentially get advance warning of any issues that might be brewing. But it also allows you an opportunity to try and sort of address performance issues without having to go through a full performance management process, which may later become necessary. But it can just, you know, if there's just a few things that aren't quite right, you can set objectives and you can hopefully turn that employee performance background so that they're, you know, back on the same page as you. But if then it doesn't improve and you've, you know, looked at it on an informal basis, it's really helpful for then laying a paper trail of the fact that there have been problems with this employee. Often we will see, if we look back at employment history, you know, the last appraisal was great and that was only 2 months ago, but now you suddenly want to terminate them and get rid of them because actually their performance has been awful. So using it as an honest opportunity to actually properly appraise the performance of that individual is absolutely essential. And as I say, it can then sort of create a bit of a pattern of the fact that there have been, you know, if that later there are performance issues, or if there are conduct issues, that employee, you know, can't get on with other colleagues, you've discussed it with them, and it's not then going to come as a complete shock if you then end up having to take more formal action against them. So effective use of appraisals, again, really, really important, and it's something that we often see isn't utilised to its full effect. So then just looking at sort of, I've talked a lot about terminating staff, and obviously, you know, that is normally where we see employment tribunals come from. So I'm just going to spend a little bit of time again going over the basics, which I know many of you will be familiar with, but as I say, it's quite often these sort of little mistakes in the process that we see that then end up resulting in employment tribunal claims. So getting all of this absolutely right is, you know, essential to protect your business. So you'll all know that there are 5 grounds to dismiss an employee, that they're on the screen. You'll be familiar with all of them, so I won't go through them in a great deal of detail, but you'll also know that retirement is no longer a fair reason for dismissal unless you can justify it. So, you know, certainly getting rid of somebody because they're too old is, you know, no longer a good idea, and can certainly lead to discrimination claims. So be very careful around doing anything like that. So you need to concentrate on those 5 grounds there, of which obviously at the moment redundancy is one of the most common. You will have all dealt with sort of conduct issues. Capability can either be through ill health, so someone on long-term sick leave, or through a performance issue. Illegality isn't used so often. That would come into play, for example, if you've employed someone and they lose the right to work in the UK, it would be illegal to continue to employ them, so you can terminate on that basis. And then some other substantial reason, which is kind of a bit of a catch-all, which would apply, you know, where 2 employees can't get on with each other, for example. And we'll go on to look at how sort of each of those apply. You'll all know that an employee has to have worked for you for at least 2 years before they have the right to claim unfair dismissal. So that is why when you speak to Gary or I or another member of the employment team, one of the first things we'll say to you is how long have they worked for you? And that's because we're assessing whether they are going to have the right to claim unfair dismissal and assessing the risk to your business, really. So if you've got someone who's been with you for less than 2 years, because they can't claim unfair dismissal because they don't qualify to bring that claim in the employment tribunal, you wouldn't necessarily need to follow the full procedure that you would do for an employee who has more than 2 years service. So effectively, it's much easier to terminate somebody when they've been with you for less than 2 years for, you know, any reason that you want to, really, provided it's not a discriminatory reason. So again, making effective use of that 2-year period. You know, if someone's been with you for nearly 2 years, you know whether they're going to be able to do the job or not. So again, perhaps making a diary note of when that 2-year period is coming up for expiry is quite a useful thing to do, because once you've gone over the 2 years, it's much harder to get rid of them, and you're also then going to have to pay them redundancy pay, which is another right that kicks in after 2 years. So bearing that in mind at all times is a good idea. If you've got an employee who's been with you for less than 2 years, it's not to say that they can't bring any claims at all. They can still bring claims for discrimination and whistleblowing and unpaid wages or notice and things like that. Those are all rights that run from the very first day that they start working for you. So you're not completely out of the woods if you've got someone for less than 2 years. And what we find actually is, particularly at the moment, once an employee becomes aware of the fact that they've got less than 2 years service and they can't say that they've been unfairly dismissed, they'll try and shoehorn their claim into, you know, a discrimination claim or a whistleblowing claim so that they can do something against you. They can take some kind of action. And unfortunately, the employment tribunal don't really sort of filter claims out based on whether they think they've got good grounds to bring a claim against you or not. They'll let everyone have their chance, and very often it means that you have to go all the way through to the end of the process, unfortunately, even if they decide to, you know, shoehorn their claim in and it's got no merit. So setting, you know, some of these ground rules, which I'll go through, is really important to prevent those kind of sort of vexatious claims as well. So making sure that you keep that 2-year period in mind is important, but it doesn't mean that you're completely out of the woods. And as Gary said, you know, claims generally don't cost the employee anything. It used to be that they would have to pay quite a chunky fee to pursue a claim. That went a few years ago, and ever since then we've seen claims go up and up and up, and at the moment I think we're kind of back up to record levels, particularly with the amount of job losses that have been happening over the last year or so, and which unfortunately are going to continue. So there's no need for the employee to put their money where their mouth is, which used to be the case if they, you know, had to pay something to bring a claim against you. There's no cost consequences. So even if you win the case against them, you successfully defend a claim, you don't get your legal costs back from them. So there's pretty much nothing for an employee to lose. So that is why sort of setting the groundwork, doing everything by the book as much as you can is really important, just to hopefully head off the claim, so that if they then trot off to a solicitor and say, I want to bring a claim against my employer, and you've done everything right, then hopefully they'd be advised not to go ahead and do that, because there's not much merit in their case. And often what we see is that all of you guys who are on this webinar today and who are, you know, HR or employment, you know, looking into the practicalities of how to deal with all of this stuff, you'll all know what you need to do and the process and stuff like that. But actually what we see is that it's the managers that might not be following the rules within your organisation. So you need to make sure that all of your managers are trained and know what they should be doing when they're dealing with disciplinary matters, or, you know, performance management, or any kind of employment issues. And Gary and I, you know, train staff for a lot of our clients to, you know, make sure that they are up to speed with what they should be doing. And actually it's always quite surprising when people say, you know, oh, well, can't I just do that? And I thought that I could do it this way. So making sure that your managers know what they should be doing is absolutely essential. Having somebody who's kind of got an overview of the employment matters or within your organisation is very useful as well. So you might not have an HR manager. It might be one of you, unfortunately, has got the lucky job of doing HR with all of the rest of your day-to-day duties. But having someone who's the central point of contact is actually really useful, because it means that you've just got an overview about what's going on within the organisation. And that can help ensure consistency in the outcomes that are happening. So you might, for example, have an employee who's been caught stealing. If you dismiss one employee for doing that, but you just give the next one who does it, you know, an oral warning, then there's no consistency in how those employees are being treated. So just to have an overview about what's happening within the business, making sure that there is consistency can be really useful. And, you know, hopefully it means that those managers will speak to you before they go and make some rogue decision that's potentially going to land the business in hot water. And you'll all be familiar with this, but the importance of putting everything in writing, you just can't underestimate that. As Gary said, you know, particularly at the moment when employment tribunal claims are dragging on for a long time, what we're seeing more and more of is that people are leaving businesses and then there's no one to give evidence to be your witness for the business about what's happened. And if you haven't even got anything in writing that you can refer back to, you're just not going to know what happened at that meeting when, you know, that person was dismissed, or you know, why that particular decision was taken. So now more than ever, putting everything in writing is absolutely essential. So that includes, you know, taking minutes at meetings, writing to employees to tell them the outcome when you've made a decision about something. And even if you're just having an informal meeting, so, you know, you might have a quick chat and an employee discloses an issue to you, just go back to your office and just make a note of it. You don't need to get the employee to sign it or, you know, to even give them a copy, but just to make sure that there's a record of it, because in 2 years' time, if you end up at an employment tribunal, you're just not going to remember exactly what was said. And from the employment tribunal's point of view, they love seeing stuff in writing. If it's not in writing, then it's just your word against the employees, and it just comes down to who the judge believes on the day. And that pretty much depends on what way the wind's blowing, what mood you've caught them in. You know, employment judges can be really moody, and it just, if the employee comes across as a more believable witness than you, even if they're wrong, then, you know, you're going to have a problem there. So absolutely putting stuff in writing and being able to say, yeah, on this date we had a meeting, this is what we said, on this date I, you know, wrote to them and said this, is really, really important. So put everything in writing absolutely as much as you can. So now I'm just going to run through the kind of the rough process of the formal process that you need to take. And I'm calling it a disciplinary process, but it applies in sort of all of those 5 grounds that I've spoken about, aside from redundancy really. But I'll run through the rough process, and then I'll go back and sort of tell you how it differs for each of the grounds. And you'll be familiar with this anyway, but basically there's sort of 4 stages if you're going to take formal action against an employee. The first one is to get the evidence together to show that, you know, there's something that you need to speak to them on a formal basis about. And normally that means carrying out an investigation. So it would be, you know, perhaps speaking to other employees, looking for documents, basically trying to do anything to show that there are grounds to take formal action against the employee. But you should also be looking for evidence that might support the employee. So, for example, you might have caught someone stealing, and actually if you carry out an investigation, you might find out that the reason they've been doing that is because they've been put under pressure from another member of staff to, you know, steal stuff off of site because they want to sell it, and they're just being bullied into it, in which case your disciplinary action is going to completely change from being against that employee that you thought was stealing to be against the guy who's forcing him to do it, potentially. So the investigation can completely change, you know, the course of the process, and that's what it's meant to do. You're meant to keep an open mind at that early stage. So basically you're looking for grounds to take formal action against the employee. You can suspend the employee during that period if you want to. Normally the disciplinary process will allow you the right to do that. Normally you're paying the employee full pay during the period of suspension, so obviously from a business point of view you want that to be as short as possible, and really we'd only recommend suspending an employee in most circumstances for no more than a couple of weeks, because if you leave it too long then you're potentially getting yourself into difficulty where that employee's left hanging and they're stressed, and you don't want them to then resign and bring some kind of claim against you for constructive dismissal. So making sure that you're doing the investigation, keep them away from the business and suspend them if you need to, but try and do that as quickly as possible. Often we're asked, do I always have to do an investigation? You might find that actually you've got all of the evidence, the employees admitted to the conduct that you've accused them of, for example, in which case then you might decide actually there's no need to do an investigation. You've caught them red-handed, or they've already admitted to it, you've got all the evidence you need, and then you go on to the disciplinary process. So in some circumstances it might not be necessary, but usually it is, and the Employment Tribunal will want to see that that investigation has been as comprehensive as possible. As I say, looking for evidence that supports your case and supports the employee's case as well. So the next stage, once you've decided actually yes, we've done the investigation, we've got evidence, we're ready to go to the formal stage, is to call the disciplinary meeting or the formal meeting. So that basically means writing to the employee, can be a letter, can be an email. Basically, you need to just tell them this is, we need you to come to a formal meeting, and you need to tell them what you want to talk to them about. So that might be that you're accused of gross misconduct and we've caught you stealing, and this is, what we think has happened. You basically need to give them enough information that they can prepare for the meeting, so that they know what it is that they're coming to speak to you about. You can't just say, come to a disciplinary, leave it all, a bit secret, and then hit them with everything once they get there. And we do see that. The Employment Tribunal would say that that's not a reasonable way to conduct it. It's not fair on the employee because they haven't had a chance to prepare themselves to answer those allegations. So telling them what it is that they're needing to come and speak to you about is really important. Giving them the right to be accompanied to the meeting is really important as well. That's a legal requirement. But the law just says that you only have the right to be accompanied by a colleague or a trade union representative. Often people will ask to bring other people with them. So they might say, I want to bring my friend, or I want to bring my mum with me. And normally, if you ask us, we would always say, try not to allow that, because you just don't know who that person is that they want to bring with them. They might be an employment tribunal judge. They might be, certainly if you've got someone's mum there who doesn't agree that you're trying to discipline poor Johnny, and he's a good boy and he, never do anything wrong, you're going to find yourself arguing with that mum rather than addressing the disciplinary action, with the employee. So the law just says, just have a colleague or a trade union representative as the person that the employee is allowed to be accompanied by, and most of the time we would recommend that you stick to that. There's certain circumstances where you might want to adjust it if someone's got a disability or there are exceptional circumstances, but normally we'd suggest just stick to what the law says and just the colleague or the trade union representative. Making sure that you give enough notice of the meeting is also really important. It might be that you think you've got the employee bang to rights and this is all going to be a very open and shut situation, but actually you need to make sure that they've got enough time to prepare, again, just to be seen to be reasonable. So in most circumstances we'd recommend at least 2 or 3 days notice that you're giving when you're writing to the employee to invite them to a meeting. Give them at least 2 or 3 days to show that you're being reasonable. That allows them all the time that they need to prepare, and you might want to allow a little bit longer if there are a lot of documents for them to consider. So just judge it based on the circumstances, but certainly allowing at least 48 hours notice is normally what we would recommend. Sometimes an employee might, upon being invited, might just say, I want to get it over and done with. Can I come in, this afternoon or tomorrow? And if, they are happy with that and you can document that you've checked with them that they're happy, then, sometimes that might be an okay thing to do, but normally we'd suggest at least 2 to 3 days. Some staff handbooks, so some disciplinary policies or other procedures might include timescales. I certainly, when I'm drafting policies, try not to put any timescales in, because I think it's not always easy to stick to them, and an employee, as you'll know, once they've got something in writing, they expect it to happen. So in normal times, when we are allowed to go on summer holidays and things like that, you think sometimes it's quite hard to find a manager who would be around to deal with something within, say, 5 days of the employee being notified of it. So I would normally suggest that don't put timescales in the policy. It just makes your life easier, so that you've got a bit of flexibility, but you may have them in there, in which case try and comply with them if you can. And the whole point of inviting them to this formal meeting is basically just to let them have their chance to explain their position and to give you any evidence that they might need to support it. So there might be a completely reasonable explanation why they did that thing that you're accusing them of, in which case the formal meeting is the opportunity for them to explain that to you, and you may change your mind once you hear from the employee about what it is that they're accused of. Making sure that you're taking minutes, as I said, keeping an accurate record of the meeting. Quite often what we see now is just doing an audio recording of the meeting. As long as the employee is happy with that, that can be really useful. It certainly makes life easier if you're then taking notes. It helps if there's a dispute later about what was said at the meeting, because then you can't argue with the recording. But what we're seeing more and more of is an employee who wants to perhaps secretly record the meeting. So we would always suggest now that you check with the employee at the start of the meeting that they're not recording it without your permission, and just be wary of that. I mean, there have been cases where potentially you've had this formal meeting, you send the employee out to go outside while you make your decision, and they may have left their handbag on the chair with a phone in their recording, and if they're recording then you discussing what outcome is going to be from the meeting, and you're saying things that potentially they could use against you, you don't want that to be happening. So just be wary. Employees are doing this more and more of kind of covertly recording things, and they shouldn't be doing it without your knowledge or consent. So if you're offering that you're going to do a recording of the meeting, then that keeps you in control of that information. So that's always worth checking with them. And as I said, you still need to go through this process, even if you think the employee's absolutely done whatever it is that you think they've done, or that there's no possible explanation for it, or they've admitted it. You still need to go through this process, because they can soon change their mind and turn on you, even if you think that they're accepting of the situation. The only time that potentially you wouldn't need to go through with the disciplinary would be if they decide to resign, for example, before. And employees do that quite often because they don't want a dismissal or whatever on their records, and you may then decide, actually, we're not going to go through with the disciplinary because there's no point. There might be circumstances where you feel that you should still go ahead with it if it's a particularly serious matter, or say you've got safeguarding obligations where you might need to tell a future employer that the person works with children and they're a risk or something like that. But most of the time, if you've called a disciplinary meeting, there's an issue, you need to do a disciplinary meeting and you need to go through the full process. As painful as it is, I know that from advising many of you that this is so frustrating, having to go through all of this process, but it's absolutely key. And we see the Employment Tribunal go through it in painstaking detail about how much notice did they give, what was discussed at the meeting, did the employee have the opportunity to respond properly. And so if you've ever been in the Employment Tribunal, you know what I'm talking about, and you'll be so glad that you jumped through all the hoops that you needed to, just to make sure that you are presenting your case as best you can. So the next stage is to confirm the outcome of the meeting. So obviously put it in writing, as we've said. If it's a disciplinary process, that might be giving them a warning, it might be a dismissal, or you might decide actually there's no further action that needs to be taken, but you still need to confirm that, because again, in 2 years' time, if you need to refer back, you want a document to look at. And you might also need it because it could show a pattern of behaviour. So it could be just a minor issue that you've given a warning, but it happens again in a couple of years' time. And then you can, although that initial warning will have expired, it shows a pattern of behaviour to the Employment Tribunal. It paints a picture of what this employee is like, where there have been consistent problems. So confirming it in writing is, really important. And people often think that you need to go through that full kind of hierarchy of warning. So, first warning, oral warning, final warning, and then all the way through to dismissal. But you don't have to do it like that. It might be that there's something sufficiently serious that it's a first offence, but you might jump straight to a final warning if it's sufficiently serious to justify that. So don't think that you need to, at every stage, kind of go through each one to be able to reach a final conclusion. There are circumstances where you can jump a stage in terms of the outcome that you're giving to the employee and jumping to a higher warning, for example. And another point is obviously the fact that an employee will always be able to appeal against your decision. Again, even if you think that they've got absolutely no reason to appeal against you, or whatever they decide as their grounds of appeal just have no merit, you will always have to allow them the opportunity to explain their position and to give them the right to appeal. So in your outcome letter, you should be telling them about what the appeal process involves and who to write to. Where possible, that appeal should be dealt with by a more senior manager, and somebody ideally who wasn't involved in the original decision. That's because the thought process is, if you've got a first decision being dealt with by a senior manager and then a more junior manager dealing with the appeal, it's much more unlikely that that junior manager is going to override the senior manager. So if you do it and you have someone more senior who potentially could overturn the decision and has the authority to do that, then that's the idea. Some businesses, there might not be someone who's more senior. There might not even be another manager, or the only other person available might be the business owner, or, somebody who has been involved. It doesn't always, work out where you've got this separation, but ideally, if you can, a more senior person who hasn't been dealt with the original decision is the best person to deal with the appeal. The employee should tell you what the grounds of the appeal are. They don't always. You can kind of press them to say, what is it that you're actually appealing about? Very often it might just be they don't like the decision and they think it's not fair. You can ask them to elaborate on that beforehand, but you should still go through with the appeal process, because it may be that, once they're there, they can open up a bit more about what it is. But if they can give you the full grounds before the appeal meeting, that's really helpful, because you're prepared then, you know what they're going to say. And it might be that further investigations are needed based on what they appeal. They might say that Dave knows all about it and you didn't interview Dave during the process and he should be spoken to, and then he can give an account that either supports supports the employee or supports you. So keep an open mind still during the appeal process, obviously. And the best thing about an appeal process, certainly for all of you guys listening and thinking back to kind of rogue managers who might do dodgy things and not follow the process, is you can correct all of those issues if you deal with the appeal as a complete rehearing of the case. So you start from scratch again, basically. And that can be so useful where you do find that someone has done something wrong or they haven't done an investigation or something like that. You can deal with the appeal as a rehearing and it corrects all of those previous errors. So certainly that's a good opportunity for you to hopefully claw back any issues that might have arisen. So definitely bear that in mind as the benefit of an appeal. So that's the rough process that you go through for any kind of formal meeting. As I say, sometimes you might not be calling it a disciplinary meeting if it's to do with something else. So I'll just go through how that applies to each of the reasons for dismissal that I've spoken about. So conduct is pretty much exactly as I've just been through. That's pretty much a disciplinary process. Obviously, if you've got, a very serious allegation that you're accusing the employee of, like theft or fighting at work, or, they've been grossly insubordinate, you could potentially look at gross misconduct for that. And the benefit of that from the business's point of view is that a gross misconduct decision means that the employee's behaviour is so serious that you can't justify employing them for a moment longer, which means that you don't have to pay them notice pay or pay in lieu of notice, which, you know, in some circumstances can be pretty expensive if you're paying 3 months pay or something like that to get rid of somebody. But because of that, gross misconduct is normally, you know, one that you need to make sure that you're absolutely certain it's the right decision. And Gary and I and the rest of the employment team are quite often sort of around just as a sounding board, really, to give us a call and say, you know, this is what's happened, we're thinking about doing this, what do you think? And in some situations, you know, we would say, no, that's not a gross misconduct outcome, you know, definitely don't sack them, give them a final warning or something like that. So we're always around to, you know, to give that kind of steer if that would be helpful. But any other type of conduct, so as I say, it could be that you're giving a warning or a final warning or something like that, or if you're dismissing them for something other than gross misconduct, so you might have gone through a full warning process where they've had each stage and the only thing left is to dismiss them, you're going to have to pay them notice pay unless you're dismissing for gross misconduct. So bear that in mind. And then obviously you've got to pay them for any untaken holiday and pay up until the date that you make that decision. So conduct is pretty much that disciplinary process that we've just been through. Redundancy is kind of a whole other topic in itself, and I think, you know, Gary and I have done webinars on that, you know, recently, but the process is different there. You need to, you know, go through a slightly less kind of confrontational procedure where basically you need to identify that there is a redundancy situation. So, you know, at the moment, most commonly loss of work, or, you know, you decide to restructure the business so that actually that employee is no longer required, or there's less employees required. So you need to identify the redundancy situation, look at who it might affect, warn those individuals they're at risk of redundancy, find a fair way of selecting who out of that group is to be made redundant. So looking at, you know, past performance or disciplinary records, their skills, things like that, and applying scores to them. Whoever's got the lowest score is the ones to be made redundant, and then consider if there's any alternatives. So it might be that there's another job available in another section of the business that employee could do, which would avoid them having to be made redundant. So as you'll see, completely different process, normally sort of requires a few 2 or 3 consultation meetings to discuss this with them. But ultimately, if they're not able to be retained within the business, you're paying them statutory redundancy pay, notice pay, and their accrued holiday. In some organisations, there may be enhanced redundancy pay, so obviously bear that in mind. But a different process, which is really, as I say, a topic all in itself. So ignore what I've said about the normal process to follow in a redundancy situation. But then capability, you follow the same kind of process as the disciplinary process, really. And as I said, capability can be either for poor performance or ill health. So if you're going down a poor performance route, you're still, you know, inviting them to a formal meeting, you're telling them what the performance issues are, but you're giving them an opportunity to improve, and you're using the warning system to accelerate that. So for a first formal meeting about poor performance, you're calling them to a meeting, telling them what they've done wrong, listening to any explanations that they've got, and then if there's no reasonable explanation for their performance not being up to scratch, you're going to give them a warning and you're going to set them objectives to improve that performance. So things that they can easily work on, and you'll give them a timescale for that improvement to be made. So, you know, depending on what it is, might take 3 months, something like that. And then you do another review meeting in 3 months' time, see where they're at. If it's still going on, you do the same thing again and again and again until eventually you get to the point where you've exhausted all of the warnings and you're able to then terminate them on the basis of poor performance. But I know from speaking with many of you, this is the one that you hate the most, because it takes such a long time to get to that final point where you're having to dismiss for poor performance, which is where using that 2-year rule, you know, if someone's worked for you for 2 years, you're going to know, less than 2 years, you're going to know whether they can do the job or not. So getting rid of them earlier than before they hit the 2-year mark, and then you have to go through this full process, is going to be better. As I said, capability is also related to ill health. So if you've got an employee who's been on long-term sick, for example, or they've had an accident and they're no longer able to do the job that you employed them to do, the process is still, formal meeting. Normally, you need to have a medical report to establish that either that employee isn't fit to do the job, or that they're not going to be able to return to work in the foreseeable future. And the purpose of the formal meeting then is to really discuss that with the employee, see whether there are any alternatives. This kind of dismissal for ill health runs the risk, obviously, of a discrimination claim, because you might have an employee with a disability or something like that. They might be off sick because they've got cancer, which is automatically a disability. So you need to tread carefully, and it's certainly sort of one where if you've got an employee on long-term sick and you need them, to return to the business, but they don't look like they're going to be able to, it's probably one that we would recommend having advice on, just to make sure that you're teeing everything up and doing it in the right way. But the formal meeting process, as I've said, sort of remains the same. And then some other substantial reason is the other one. So again, still need to do the formal meeting process, and it can cover, as I say, a kind of wide range of situations. So it might be that two employees can't get on and you just can't continue to employ both of them. You can dismiss, one or both of them. You might have a client who doesn't like an employee that you've got working on their site, and it's just a personality clash, for example, or they don't like their attitude, and you haven't got anywhere else where you can put that employee. Then potentially you could be looking at some other substantial reason as the basis for terminating them. And as I say, the process is exactly the same. Invite them to a formal meeting, tell them what the problem is, listen to what they've got to say, and then give them the outcome and put it all in writing. So you can see that basically the formal meeting process stays the same across all of those reasons for termination, save for redundancy is slightly different. So, invite them to a meeting, talk about things, give them the outcome, put it in writing, give them the right to appeal, is basically the simple summary of what that procedure is. And many of you will be familiar with settlement agreements. It's something that quite often we may discuss with you when we're giving advice about how to handle particular issues. Some businesses use these just as a matter of course in all circumstances, even where there might not be an issue, just because it's a cleaner way of bringing employment to an end. And basically a settlement agreement is a document where employment is terminated on the basis of what's in the settlement agreement. The employee is normally paid sort of slightly more than their legal entitlement, so slightly more than just notice and holiday and that kind of thing. But in return, they agree not to bring any claims against you. So you have the certainty of knowing you're not going to end up in an employment tribunal. It's much quicker because you haven't got to go through that horrible process that I know most of you don't enjoy. And it just saves all the management time that you would have to expend on that process and all the stress and everything else. So it's something that very often we might consider with you on sort of a commercial basis, just so that you've got the certainty of knowing that you're not going to have any comeback. You haven't got to worry about ending up in the employment tribunal. It's obviously a bit more expensive for you because you're paying more than the statutory and contractual entitlement that the employee has, really as the incentive for them to enter into the settlement agreement. And you also would normally be expected to pay for their legal costs for them to go and see an independent solicitor to run through the terms of the agreement with them. That's normally kind of somewhere in the order of like 250, 500 quid. So not a lot, but it's obviously an added factor. And it's not appropriate in every situation, but it can be something that's worth considering, particularly if you know you've got an employee who is a bit militant, or you're a bit worried that actually they may try and bring some kind of claim against you. It's something that's always worth having in the back of your mind about whether is this a situation where we should be, thinking about using a settlement agreement. So basically the summary then of all of my yabbering for the last hour or so is that you need a good contract of employment. That's absolutely key, just to have the basics in place so that you're not starting off on the back foot by arguing about what exactly the terms of the employment are. You need to have policies and procedures in place, ideally, which you apply consistently, and that should then help your managers, make sure that they're dealing with disciplinary policies properly, but also that the employees know what they are and aren't expected to do, in those policies, like data protection or not facilitating tax evasion and things like that. Make sure that you put everything in writing. Honestly, I've seen it go wrong so much recently, where things aren't in writing and people have left the business, and it's just so difficult to try and put together a picture of what's happened to really, support your case. So everything in writing as much as possible, and acting on things early, and don't, just be nice to them at an appraisal, because you don't want the confrontation of actually bringing up these issues, and hopefully things will get better. They won't normally. So don't let things drag on. Use those probation periods, appraisal processes, or jump on the conflict with other members of staff early, just so that it's not dragging on and on, because you're going to get to the point otherwise where you'll turn around and think, I want to get rid of that person, but you haven't laid any of the groundwork, and it's going to make it much more difficult. So acting on things early is really important. So hopefully that's been useful as sort of a bit of an insight about the basics where we see things go wrong, and these things can be easily remedied. I'll pass you over to Gary now, who is going to talk about other ways that you can protect your business, and hopefully not so much doom and gloom about employment tribunal claims.
Brilliant. Thanks for that, Joe. So yeah, as Joe says, obviously it is key to try and avoid these claims if you can help it, but that is only sort of part of the job in terms of protecting the business and keeping the business safe, because it's all well and good looking to avoid a tribunal claim, but if the employee then takes all of your client data, takes half of your customers down to your competitor down the road, that can be absolutely devastating for your business, just as an unsuccessful employment tribunal claim can be. So it is fundamental that we also look to get that right. And for the remaining time available to us, I'll just sort of look through some of the steps you can look to take to do that. Now, the first point to cover is actually the law does give you some protection, absent written employment contracts and all the rest of it. There is what's known as this implied duty of fidelity that goes into every employment relationship, and requires the employee to act in the employer's best interest. Now, that is not as onerous as, say, a director's fiduciary duties, but it is still to act in the employer's best interest. So things like protecting confidential information would fall within that. And typically, the example would be that 2 or 3 days before the employee leaves their employment, they send your entire client database to their personal email account without any real business rationale for doing it. And so you can then rely on this duty of fidelity to potentially get that information returned and to prevent that from being used or disseminated elsewhere. Now, the duty of fidelity does end when, or more or less ends when the employment has ended. But if they have acted in this way prior to the employment coming to an end, then you potentially have that recourse. But the first and most important tool you have available to you, as Joe has said already, is the contract of employment. Okay. Now, firstly, you would be looking to include an express clause within your employment contract that protects your confidential information. Make sure when you're drafting this that it firstly applies not only during employment, but also upon termination. So when they leave, that can be an open-ended protection, although that's without time limit. So obviously the information becomes less and less relevant the further we go beyond it, but it gives you that protection. And ensure that confidential information is properly defined within your contract, because what is confidential to some companies is not necessarily confidential to others, and you need to make sure that is properly covered. The next element then you would look to be introduced into your employment contract are restrictive covenants. Now, restrictive covenants have a bit of a bad reputation for reasons I'll come on to, but initially, what do I mean by restrictive covenants? So these are clauses that apply to the employee after the employment relationship comes to an end. Okay, and there are typically 4 types. The first one is on the screen there. It's a non-competition provision, stops them from working for a competitor, normally within a certain radius of your business and for a specified period of time. But they cannot go and work in competition with you. The second one that normally we see is what we call non-solicitation. So the employee cannot go after your customers or your suppliers, however that may be. So they cannot actively go after your customers for a period of time. But that, of course, is only half the story, because what happens if the clients, the customers, the suppliers go to that employee? And so we put in a non-dealing clause to say, actually, for a period of time, the employee's got to say, no, stay away. The final one, and actually the one most people often miss or take less care over, is the non-poaching. So it's bad enough you've lost one employee to your competitor. You don't want to lose 3, 4, 5, 6 of them as their buddy phones them and says, I'm getting paid a lot more down the road, come and join me. And suddenly you see all these people you've trained, brought on, developed, passing on to a competitor business or to any business. And so you would look to stop them poaching employees or even whole teams. Now, typically that would be restricted to senior employees, but it can apply to any, depending on the circumstance. Now, the reason the restrictive covenants have a bad reputation is because on the face of things, they are all unenforceable. Okay, they are a restraint of trade. Okay, on a matter of public policy, the government doesn't, and everybody doesn't want people on the unemployment register receiving dole, receiving benefits open-endedly. They don't get to keep their skills updated. And frankly, the government wants competition, the old Darwinian idea that survival of the fittest. You want that constant competition. However, the courts have recognized that the employment relationship is a very particular type of relationship. And although the employees are largely subservient to it, the employers also place a lot of trust in their employees. They give them access to their confidential information. They give them access to their customers, their clients. You give them access to, you give them the platform on which they can perform to build up their own relationship with your clients. And it would be unreasonable then to give you, as an employer, no protection at all. Having said that, that protection is limited. And is quite restricted. It is only where you can identify a legitimate business interest you're looking to protect. The covenant itself must be designed to protect that legitimate business interest. And it must afford no more than adequate protection to the business. And this isn't new law. I mean, you can see there, Herbert Morris Saxby, that's 1916, that's 105 years. This has been the settled law, and so it's remarkable really how many employers don't make more use of this. It is there. It is an important tool for you to use. So, what then are the legitimate business interests you can look to protect? Well, the courts have identified 3. They've said that they will, but they are open to recognising others. But these are the only 3 that have been recognised today. So, trade connections, so customers, clients, or suppliers, and more generally your goodwill. You can look to protect that. You can look to protect your trade secrets and your other confidential information, and you can look to protect the stability of your workforce. Okay, those are the 3 you can look to protect. To assist with this in the drafting of the covenants, it's helpful often to include some introductory wording to identify the business interest. So it'd be something along the lines of, in order to protect the company's trade connections with its customers or clients and its trade secrets and confidential information, you covenant with us that you shall not, ... Okay. What you do have to be careful though with is once you've included that introductory wording, you will be judged by it. And if the covenant doesn't refer, it isn't relevant to the introductory wording, you're not going to get the covenant enforced. Now, the question then of the adequate protection, no more than adequate protection, this is assessed on a case-by-case basis, but importantly is judged on the reasonableness of the covenant at the time the covenant is entered into. So if you've got an apprentice, enters into an employment contract with restricted covenants, works their way through all the seniority up to being managing director or CEO, and no new employment contract is entered into. Now, those restricted covenants may be reasonable as against a managing director, but we're not going to be judging them against his position or her position as managing director. It will be judged against the position of an apprentice, trainee, graduate, whatever they come in as. So that is really important, that when you do employ people, you get the covenants in, but equally when you promote them or move them to another role, that you look at a new contract or at least new covenants to make sure that they are still relevant and up to date. Now, employee salary and seniority is strictly speaking irrelevant, as it says on the screen, but naturally, the more senior the employee, the more of a threat they tend to be. So the more you can get in the way of covenants. Then the question comes as to their duration. Okay, now typically they're 3, 6, 9, or 12 months. Now 12 months is, generally speaking, the maximum you can ever hope to have, even for the most senior employees. Now that is not, there may be some instances, for example, if you're working, say, an insurance broker and you have annual renewals, you could get some relatively junior staff on 12-month covenants, so that you get at least one cycle of renewals in before the employee can start competing with you or going after your customers. But typically you're looking at about 6 months for most employees. Now, importantly here, the key thing to remember is that the tribunals will not rewrite your covenants for you. Okay, so if a covenant is there for 9 months, let's say a 9-month non-compete, and the tribunal says, well, the court says, well, look, a 9-month non-compete is too long. 6 months would, though, have been reasonable. They will not replace the 9 months with a 6-month covenant. Okay, you will simply lose the 9-month covenant. It is too long, and you will get no protection at all. So on the one hand, you've got this desire to get as much protection as you possibly can. On the other hand, of course, you want it to be enforceable, and the two will compete against one another. And so you need to bear that in mind when you're setting your covenants. Okay. So once you've put the covenants in the contract, you then get an employee resign. They're going to work for a competitor. You're worried about enforcing them. Well, the first thing you would do is just remind them of the restrictions. So you'd make clear to the employee, look, that's fine, but please note, you're not allowed to go after our customers. You're not allowed to deal with our customers. You're not allowed to pinch our staff. These clauses in your contract confirm. You can also, though, make the prospective employer aware. So they request a reference, say, yeah, they worked for us, they were great, really good. But please note they have these restrictive covenants. Now that is relevant because you can potentially bring a claim against not only the employee, but the new employer for procuring the breach of the restrictive covenants. But you can only do that if the new employer knows of the covenants and has knowledge of it. So you writing to them puts them clearly on notice. And of course, the new employer has more money. So if you are faced with potential losses, you want to look to claim off them if you potentially can. Importantly, it's worth noting that you need to act quickly to prevent damage to your business. It's no good waiting 2 or 3 months for half of your clients to have disappeared before you act. You need to act quickly, same day, next day, over the course of the week that follows, to make sure that we can protect your business as fully as we can. Typically, that would involve sending a strongly worded letter, sort of an angry, shouty solicitor's letter, demanding that they comply with the restrictive covenants. And typically, we would ask them to enter into formal undertakings, so that's formal promises to comply with those restrictions. Often, probably 8 or 9 times out of 10, that is what ends up. Normally there's some haggling on the undertakings, but that is normally what ends up being agreed. But in those cases where that can't be agreed, you may be forced into the realms of seeking a high court injunction, but that can be extremely expensive. You can look at £20,000–30,000 worth of legal fees in a very, very short period of time, and the risk of having to pay the employees legal costs at the High Court if you lose. Now, however, that is a really powerful tool, because an injunction is effectively a High Court order that says you, employee A, and prospective employer or new employer B must comply with these restrictive covenants for their duration. That's a formal court order. If they ignore that, they're in contempt of court. There's potentially even criminal sanctions, potentially going to prison. So it is a really draconian step, and employees want to try and avoid that, because yes, it's expensive for you, but you will often be able to afford it far more than the employee can. So that's why we often get to the undertakings, but not always. So you do have that option of an injunction if push comes to shove. If you do go down that route, though, you've got to be aware that the courts are very, very picky in terms of the covenants they will enforce or not. So in this case, 2017 case that went up to the Supreme Court, you shall not directly or indirectly engage or be concerned or interested in any business carried on in competition with any of the businesses of the company or any group company which were carried on at the termination date or during such period. That was held to be too wide. It was therefore unenforceable. All protection was therefore lost. The reason for that is that it was any business the company undertakes, not any business the company undertakes with which you were engaged or involved. Okay, so simple 3 or 4 words take something from being enforceable to unenforceable, or vice versa. So it's really important that you get these clauses right. What can you do to ensure enforceability? Well, firstly, you can never be 100% sure they'll be enforceable, because we don't know what the judge is going to do. But the shorter and narrower the restriction is, the more enforceable it's likely to be. Obviously, as I say, you've got these competing interests. You want as much protection as you can, but you want it to be enforceable. So how do you marry those two up? Importantly, do not issue the same covenants to all staff. We see this time and time and time again. Managing director, employee, junior employee, apprentice, cleaner, everyone has exactly the same covenants. They're unenforceable for the simple reason that you've not identified the legitimate business interest you're trying to protect from that employee. Okay. Now, obviously, if you have employees in the same role, doing the same sort of job, they may well have the same covenants. But you need to be looking at it in more detail rather than just issuing out the same contracts to absolutely everybody. A really powerful tool when you're looking to enforce covenants is if you take a note at the point that covenant is entered into. So at the point you recruit them or you promote them, you issue them the new employment contract. A small note saying we're trying to protect this because we're going to give access to these key clients to which they've never previously had access. That's going to be a challenge. We do have others who are involved with those clients, so we're taking other steps to mitigate our risk. but they are potentially at risk, and we need a period of time to get their replacement in, say 6 months, to recruit and to train them up and get them to meet our key clients. If you then turn around and say, okay, right, so there's a 6-month non-solicitation or non-dealing provision to protect those clients, and a year, 5 years' time, whenever that employee leaves, they've gone to a competitor and they have taken that client, you can turn around and say, well, hang on a minute, this is what we said we were concerned about in advance. This is what we put in place, and this is what's happening. Therefore, please enforce our covenant. It's a hugely powerful tool, and unfortunately, not enough employers make use of it. Obviously, you want to make sure you've got clear drafting. You want to expressly exclude small shareholdings. So that covers things like pension ownership and again, going back to how pernickety the courts can be on this. Now, the final point on restricted covenants is that some employers just take the view, well, I'm never, ever going to enforce these covenants. I'm never going to put that sort of money into getting an injunction. I'm not interested in that, but I will use them for what we call bluff value. So they'll have 12-month covenants for everything, and then they will sort it out with the employee later. It may be that they send angry, shouty letters. They then agree to concede the non-competition covenant on the basis the employee agrees to abide by the non-solicitation and non-dealing. And so that can be is a perfectly acceptable course to take, as long as you accept that the covenant will not be enforceable, and that's just how it is. So the final couple of slides then, before we take any questions, we're looking at garden leave. Now, garden leave is hopefully familiar to all of you. You send your employee home, they don't get any duties, or they get alternate duties, and they can basically sit in their garden for 2 months, 3 months, however long their period of notice is. A hugely valuable potential protection available to you. Now, on the one hand, they are far more enforceable than restricted covenants, because they're your employee. You can have them do within reason what you wish for them to do. The downside compared to covenants is that you have to pay them for that period of garden leave. They're your employee. They're still employed. You've got to pay them. But that is perhaps a cheaper way of doing it than enforcing restricted covenants and going down in the injunction route. And so garden leave should always be there as a balance with the restrictive covenants, so that you have options, you have choices as to what to do. So you need to make sure that that is there. So that is us for today. We're conscious of time. We've got about 5 minutes or so, unless you are all happy to stay on for a bit longer. I hope you found today of use, and on behalf of Joanne and myself, thank you for joining us. We are, as I say, happy to take questions now. Pop them in the chat box. We will pick those up as we can. If there are any particularly sensitive questions, or if you want to have a conversation with us more generally, please do drop us an email or give us a call. You've got our details on the screen there. We will be sending you a quick email just as a follow-up, just seeking some feedback on today's session. We'd be very grateful if you could fill that in, because we write these and what we think will be interesting to you guys, but to have that feedback as to what you would like us to cover in future seminars is always hugely helpful. So so thank you very much for joining us. So I'm just having a look to see what questions we have. So we've got one in so far. So can you keep a warning on a personnel file even after it has expired? Joe, do you want to pick that one up?
Yeah, sure. Yeah, yes, you can is the answer, and it's quite helpful to have that, because, as I say, it will show a pattern of behaviour. What you shouldn't necessarily do is to take it into account if there is another disciplinary matter in the future, if it's already expired, then you can't necessarily say, oh, well, you know, you've already had a warning for something, you know, if it's unrelated, you've already had a warning for that, and so now we're going to do this. So you shouldn't necessarily take it into account. But I have seen it where there's been, you know, a pattern of behaviour. So you've already disciplined an employee for a particular, you know, misconduct, and you've given them a warning, you've told them what they should and shouldn't do, and then their warning expires, but say in a year's time they do exactly the same thing again. It can be useful, as I say, to show a pattern of behaviour. So you can keep it on file. From a data protection point of view, there's absolutely no problem with doing that. You can keep information about an employee for, you know, normally up to 6 years after they leave your employment, and it's still, you know, relevant to their employment to keep it on file. But just be careful about how you take it into consideration, basically. The answer.
Thank you. Are there any other questions potentially coming through?
I haven't seen any others come through. Unless anyone wants to unmute and jump on and be brave and ask us anything.
Okay, we've got another.
I did send one. I'm not sure if you saw it yet. It's Karen.
Okay, well, where there is a claim for unpaid wages from an employee with less than 2 years service, is there a cut-off date for making this claim? So it depends on how they look to bring that claim. So there's two potential options available to them. The first one is for an unlawful deduction from wages, and typically that is limited, has a limitation period of 3 months. Depending on circumstances, sometimes it's 6 months, but typically 3. The second way of claiming, though, is for breach of contract. Now, that would be a claim at the county court rather than at the employment tribunal. We've lost our slide there. I'm not sure what happened there. So they would be a county court claim, and that has a limitation period of 6 years. That they could bring that back, but employees rarely wait that long. If they've not been paid, they know it, and it's normally a lot swifter than that. But yeah, so that's that's there.
Thank you.
There's another one come through that says, is it okay to include the benefits that you're offering an employee within an offer letter rather than in the contract of employment, particularly as some of the benefits can change, be enhanced or withdrawn, and can the contents of an offer letter be deemed to be contractual? So yes, you can do that. And although I said, you know, you had to include details of it in the contract, you can say in the contract where that information might be found rather than spelling it out in the contract. And so some employers, for example, would sort of offer a wide range of benefits that the employee can pick and choose from. So you wouldn't necessarily have to put all of that within the employment contracts. You just have to tell them where they would be able to find that information. So yes, you can put it in the offer letter if you want, or you could have, you know, a separate source where the benefits available to them could be you know, explained in more detail. The contents of an offer letter being deemed contractual, normally no, but potentially they can. So normally what we'd put in is something like, you know, the information in this letter isn't meant to be contractual, and that the contract of employment takes precedence over it, just to avoid any kind of arguments like that. But yeah, you need to tell the employee basically what the benefits are, where they might be available to find them. So it doesn't all have to be in the contract, because in some situations that may end up having a very long contract of employment. So yeah, hopefully that answers that one. Haven't seen any others come in unless you have, Gary.
No, I haven't. Is there anything else? Anyone else? Anything else anyone wants to raise? Oh, we've got a couple more coming in.
Okay, do verbal warnings have to be formally issued via the disciplinary process? It depends on whether you're doing them as a formal or informal warning. If you're counting your verbal warning as like stage 1 of the disciplinary sanctions that you're imposing against an employee, and you want to be able to refer back to that and rely on them in the future, then definitely do it through the disciplinary process, because again, often what we see is that there have been previous issues, but if they've only been dealt with sort of informally and not via the disciplinary process, then basically anything you've done beforehand doesn't really count. So if you want to, you know, place it on record and to be able to rely on it in the future, then I would always say go through the disciplinary process. I don't know if you've got any other thoughts, Gary.
No, I mean, I think that's the key thing, isn't it? If it's formal, it's a formal verbal warning, then you've got to follow the process. If it's just a shot across the bows, a slap on the wrist, that kind of thing, then you can do it informally. But yeah, if you want it to be a formal thing, you can then rely on later to build up to a written warning or a final written warning. Then it needs to be through the process. Mm-hmm. But generally speaking, these would tend to jump to written warnings for most things anyway. If it's serious enough to spend the time doing a disciplinary process on, you typically go to a written warning.
Yeah, I agree. I tend not to use a verbal warning at all, really, unless it's something really, really minor. You're better off just going to a first written warning to then, be able to progress from there. So. Okay, I'm conscious of the time, and I haven't seen any other questions come in, so we'll release you all, I think. But as Gary said, we're both around all day, so if you want to pick the phone up or drop us an email or anything like that, anytime, we're always happy to help.
Brilliant. Thanks, everybody.
Good to see you all. Hopefully in real life soon.
See you soon.